Did y'all stop anywhere for dinner coming back from Beaumont?
Yep. Yeah, Houston, trying to remember what the place was called. It was like a French restaurant.
That you guys know.
I don't remember what it was called.
Yeah, I know what you mean. We stopped at a Mexican restaurant in Katy that I had not heard of before. It was like Los Cucos or something like that. And it was pretty good. You been there before?
They had one in the Broncos for a long time.
Cool.
I think something else.
It was pretty good. You know, good, comfort food type stuff. Lots of calories,
I
but
think it's kind of
lots
nice.
of taste.
I think it's nice to make that stop.
Yeah, it was a long trip back and lots of traffic and a couple of slowdowns. I rode with Robert on Monday. and- Oh, yeah. You told me that.
Able to see. Hello.
Okay, say that again. Okay, I just saw that.
Yep.
It's fine.
That's one more time. Hello, Napoleon. Well, it should show up on your thing.
Yeah, I see it on here, but I'm not. Okay. That's
Yep.
Have you seen the chairman around?
Good morning, everyone. This meeting is called to order. Mr. Trobman. Has anyone signed up for public comment?
Good morning, Commissioners. Les Truman, General Counsel. We have one person who would like to address the commission when we get to the policy item 8. We'll take that item up.
All right, thank you very much. Good morning, Ms. Miller.
Good morning, sir.
Oh, let's see. Agenda item 3, no cases to reconsider under agenda item 3. Is that correct?
Correct,
All
sir.
right, let's consider tax liability cases under agenda item 4. I believe we have 2 tax cases on docket 20, 0 tax cases on docket 21.
That is correct. The first case on docket 20 is TD-21-024-0821. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Disagree with staff recommendation. The motion for reconsideration should be granted, but while the property manager worked in employment, neither the bookkeeper nor the real estate agent did.
Majority vote accepts the proposal. Shall I put you down for a short form dissent?
You should. Thank you.
Thank you, sir. The second case is TD-22-005-0322. Commissioner Demerson,
I agree with staff recommendation.
Commissioner,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
And your nameplates are in the wrong places on the front of the,
No way.
yes, sir.
Who am I?
Yeah.
You're correct.
Huh?
You're Commissioner Demerson.
Okay, good. Thank you.
Uh-oh. Well, so then I will proceed over today's commission meeting. I would like the gavel, please, and make some changes while I'm here. I want to be Commissioner Demerson.
Leave mine alone.
I want to be Commissioner Demerson. Please, Commissioner Demerson.
Other duties as assigned.
I removed his. It's just the 2 of us right there.
You probably turned ours backwards. Thank you,
Chairman.
Chairman.
Thank you.
No one else said a word. So
That's just one more thing I got to start paying attention to when I walk in here in the mornings.
And that concludes the Rule 13 tax cases on docket 20. There are none on docket 21.
No fair housing cases under agenda item 5.
That's correct.
Under agenda item 6, we have no wage claim cases on docket 20 and 1 case on docket 21.
That is correct, sir. The wage claim case on docket 21 is case number 20-057991-7. Commissioner Demerson.
I agree that the employer's Rule 16 request was timely and that the employer had good cause for not participating in the first hearing. Concerning the name of the employer, the claimant and the employer's testimony established that the claimant did not perform any actual work for the company named in the initial determination, but rather that the claimant had worked for a new company that was set up to develop a CBD-related business. The other company was only named in an employment agreement that the claimant himself drafted and used for a visa application. That is an insufficient connection for a wage claim, which should always list the company for which the unpaid services were actually performed. Concerning the rate of pay, the best evidence establishes the employer's intent to pay a salary of $300,000 per year. so that part of the AT's decision, so that part of the AT's decision will need to be modified. Based on the time worked during the period of the wage claim, the claimant earned $72,884.63 in wages. The other components of the pay claimed by the claimant were correctly determined by the AT as not owed. Accordingly, we should modify the AT decision. The employer filed a timely Rule 16 request. The employer had good cause to miss the first hearing. The wage claim was partly timely. The claimant is entitled to $72,884.63 in additional wages. And the correct employer is the company named in the AT decision.
Commissioner Alvarez.
I would agree with Commissioner Demerson, modify timely petition, good cause, wage claim part timely, wages owed $72,884.63, change employer name.
Change the employer name or retain the name on the appeal tribunal decision? Just to clarify, because you said you agreed with Commissioner Demerson.
So, Ms. Miller, just so that you know, because of that, I'm going to go ahead and read the comments. Let me just go ahead and read the comments.
Yes, sir.
I agree with the commission vote on docket 6 of the timely petition to reopen good cause wage claim part timely, $72,884.63 wages owed. The parties agreed the claimant pay rate was to be $300,000 per year, which equates to semi-monthly payments of $12,500. Both parties signed an offer letter and employment agreement stating such rate. During the period of the claim, the claimant earned $72,884.63 in gross unpaid wages. Regarding the correct employer issue, the employer named on the preliminary wage determination order and the first appeal tribunal decision is correct. That was the employer listed on the claimant's employment agreement and offer letter. Additionally, there is no record the entity named in the second appeal tribunal decision existed during the claim period. The employer should be named as the preliminary wage determination order in the first appeal tribunal decision. Alternatively, as it appears the parties use the employer name on the second appeal tribunal decision at times in the operation of the business. I could agree to the listing of the employer named in the second appeal tribunal decision as an AKA. Modify the AT timely petition to reopen good cause wage claim part timely $72,884.63 wages owed, change employer name.
So you're accepting the employer name named on the first AT decision.
Yes.
Commissioner Demerson, could you clarify
Mine's company named in the AT decision, the original,
the original? Thank you.
not the original. Let me back up.
Okay.
All right, so yes, the company named in the AT decision.
First AT decision.
Yes,
Thank you, sir.
thank you.
Mr. Chairman,
Modify the AT timely petition to reopen employer established good cause for AT1 wage claim timely in part, no change to the employer name from the AT decision, $72,884.63 wages owed.
I believe we have a unanimous decision. Thank you, gentlemen. All right, no wage claim cases pulled for docket 21. You should have received wage claim short form dissent lists for both docket 20 and 21.
I move we accept staff recommendations on the remaining wage claim cases on dockets 20 and 21.
I second the motion, except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 20.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for dockets 20 and 21.
Motion passes with the exceptions noted. Let's move to agenda item 7, in consideration of unemployment insurance cases on docket 20.
Yes, sir.
Case number 27-11176, Commissioner Alvarez.
The AT should be modified regarding the petition to reopen. The claimant testified that she filed the petition as soon as she received the AT decision in the mail. Therefore, her petition should be considered timely. Regarding good cause, the claimant testified that she did not read the instructions in the notice of hearing, so she did not register for the hearing. Therefore, she did not establish good cause for her failure to attend the hearing. Regarding the separation, the claimant was fired for being absent from work. The record shows that the claimant's consistent statements to the commission were that she missed work due to being in a hospital for surgery, and that she informed the employer of her situation. The claimant's absences due to the hospitalization are not misconduct. Modify the AT, timely petition to reopen, good cause, no misconduct.
The appeal tribunal decision should be modified. The claimant's appeal should be deemed timely. As to good cause, the claimant failed to attend the hearing ultimately due to not reading the instructions in the hearing packet. This does not constitute good cause for a non-appearance. Regarding the underlying job separation, the available evidence supports the conclusion that the claimant was discharged due to unacceptable attendance, which constitutes work-connected misconduct. We should therefore modify the AT decision, timely claimant appeal. The claimant did not have good cause for a non-appearance misconduct.
Modify the AT, timely petition to reopen. Claimant did not establish good cause for AT1 misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2769162, Commissioner Alvarez.
The AT decision should be modified. I do not dispute that the claimant did not establish good cause for her non-appearance at the AT1 hearing. However, based on the record before the AT1 decision is not supportable. The documentation from the employer in the AT1 hearing establishes that the claimant was let go because she was working in a temporary capacity, and the employer found a replacement for her. She was notified that her petition would end at the beginning of the new year, and that it is when she was separated. That's when she was separated. She was separated due to a lack of work and not for disqualifying reasons. Modify the AT, no good cause, no misconduct, chargeback, void, adequate response.
We should modify the AT decision concerning the good cause issue. The claimant was mailed the notice of hearing to her correct address of record, which notified her of the date and time for the AT hearing. The claimant failed to receive the notice because she was out of town and because she failed to check her mail. Since the claimant had a duty to check her mail and the claimant missed the AT1 hearing because she failed to adequately check or forward her mail, the claimant did not establish good cause for missing the hearing. Concerning the job separation, the claimant quit because she wanted a pay increase and wanted to find other employment. The available record shows that the claimant did not afford the employer an opportunity to remedy her concerns prior to quitting. As such, we should modify the AT decision. The claimant did not have good cause for missing the AT1 hearing, voluntary leaving, no chargeback, sever the adequate employer response issue.
Modify the AT, claimant did not establish good cause for AT1, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2788860, Commissioner Alvarez.
The AT decision on the timeliness should be reversed. The claimant filed an appeal from a determination that voided the claimant's claim because the incorrect employer had supposedly been named. The employer at issue responded to the notice of claim that the claimant never worked for them. However, agency personnel then waited months to try to contact the claimant about the issue, well after the claimant stopped filing for benefits. As a result, the claimant did not respond to the injury. Moreover, his appeal was not filed until after his benefit year ended because of the delay by the agency in initiating this case. The appeal should be deemed timely as the case involves validity of claim. Reverse AT, timely appeal, and resubmit for merits. In the alternative, I would also agree to a rehear in the case since it is unclear whether the claimant even had a work separation and therefore whether the determination at issue should have been issued in the first place.
Agree with that. We should reverse the appeal tribunal decision on timeliness. The claimant's appeal period fell within the window of time that TWC was experiencing technical difficulties. The claimant testified that despite multiple attempts, he was unable to get through to TWC. Thus, the claimant's appeal should be deemed timely and the case resubmitted for merits testimony.
Reverse the AT, timely claimant appeal, resubmit.
Thank you, gentlemen.
Case number 2859734, Commissioner Alvarez.
The AT decision should be modified. I do not dispute that the claimant did not establish good cause because of his non-appearance at the AT1 hearing. I also do not dispute that the employer filed a timely appeal to the AT and a timely protest to the notice of initial claim. Regarding the separation issue, Based on the record before the AT1, the AT1 decision on the work separation is not supportable. The testimony and the documentation from the employer in the AT1 hearing establishes that the claimant's pay structure was changed from salary plus commission to straight commission. Commission wage records reflect that the claimant had a pay reduction of 40%, well above the 20% benchmark that constitutes good cause connected with the work to quit. The claimant quit the job in response to a material change in the pay agreement and therefore had good cause connected with the work. Modify the AT, no good cause, timely appeal, timely protest, no voluntary leaving, chargeback, void adequate response.
We should modify the appeal tribunal decision. First, I agree that the employer filed a timely appeal and submitted a timely protest. As to the claimant's good cause issue, the claimant did not receive the hearing packet because he failed to update his address with TWC after he moved. Since the claimant was not prevented from participating due to circumstances beyond his control, the claimant did not establish good cause for his non-appearance. Regarding the job separation, the available evidence indicates that although the employer required the claimant to make a certain number of phone calls per month, the employer did not require the claimant to meet his sales quota and did not affect the claimant's base salary. Therefore, since the claimant quit to look for another job while continued work was available, the claimant quit without work-connected good cause. We should modify the AT decision. The claimant did not have good cause for his non-appearance, timely employer appeal, timely employer protest, voluntary leaving, no chargeback, and sever the adequate response issue.
Modify the AT, claimant did not establish good cause for AT1, timely employer appeal, timely protest, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2970018, Commissioner Demerson.
We should modify the appeal tribunal decision. Time spent away from the claimant's desk negatively affected her production. According to the claimant, her medical condition caused the excessive time away from her desk, but she had been unable to obtain medical documentation to provide to the employer. Thus, since the claimant's job performance suffered because of a medical issue, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no misconduct, no chargeback, MBI, correct the employer's name and account number.
The employer discharged the claimant because she had never met their expectations. In accordance with appeal number 1456-CA-77 and appeal number 1123-CA-76, the claimant's failure to meet the employer's standards cannot be deemed misconduct. The employer provided clear testimony that the claimant was not able to meet their standards and that they were unaware of any health issues. On appeal, they have now asserted that the claimant once did meet their standards and that they were aware of her FMLA request. As the employer has changed their story, no rehearing should be provided. While the claimant was discharged for reasons other than misconduct, as her inability to perform to the employer's standards was due to a medical issue, I can agree to protect the employer's account. Modify the AT, no misconduct, no chargeback, MBI, and correct last work.
Modify the AT, no misconduct, no chargeback, MBI, correct the last work name and account.
Thank you, gentlemen.
Case number 3007799, Commissioner Alvarez.
The AT decision should be modified. The claimant took time off from work to care for her children after they tested positive for COVID-19. After a few days of being absent, the claimant tested positive for COVID-19. The claimant was unable to return to work because she had ongoing long-term symptoms of COVID-19. The employer's response to the initial claim acknowledged that the claimant reported to the employer that she was sick with COVID and still unable to return. There is no evidence that the employer required the claimant to provide medical documents to justify her ongoing absence. Instead, they encouraged the claimant to take time off to care for herself and her family. As such, we should find that the claimant was involuntarily separated from the employer with good cause connected with the work due to medically verified illness. Modify the AT, no voluntary leaving, no chargeback due to MBI. In the alternative, we should rehear the case to admit the claimant's evidence of a positive COVID-19 test result as the claimant submitted via email on the same day as the appeal tribunal hearing and disputes the appeal tribunal's conclusion that the claimant provided no documentation that she had COVID-19.
Should modify the AT decision. The available evidence in conjunction with the claimant's firsthand testimony dictate that the claimant's separation arose from her ongoing and long-term symptoms associated with COVID-19. Since the record supports a finding that the claimant's separation was the result of a medically verifiable illness, we should modify the AT decision. No voluntary leaving, no chargeback, MVI. In addition, a memo should be sent to UIA and OS to investigate whether the claimant was able or available for work.
Modify the AT, no voluntary leaving, no chargeback, disaster, memo to investigate claimant's ability to work.
We have a unanimous decision that the claimant will be qualified for benefits and the employer's account protected from charge. The majority vote will be MVI. Do you wish to dissent on the rationale?
Not really. It doesn't serve a useful purpose. So,
Thank you, sir.
yeah.
Case number 3054430, Commissioner Demerson.
The appeal tribunal decision should be reversed. The employer stated that it had offered work to the claimant for the school year because there were unfilled substitute vacancies every day. In addition, the employer stated that the substitute teachers, such as the claimant, have to log on to the employer system to check for the vacancies. Moreover, the employer stated that the claimant was aware of this process since she had used it to accept open substitute teaching jobs in the past. Between the employer stating that work was available every day and also stating that the claimant knew how to assess these jobs, the claimant's failure to use the employer system to accept further work constituted a rejection of suitable work without good cause. We should therefore reverse the AT decision, suitable work disqualification. In the alternative, I would also support a rehearing in this case for testimony on jobs available from the named employer in Richmond, Texas. Additionally, I would also like to request a memo to investigate the claimant's availability for work.
The AT decision is correct. After closing campuses due to the pandemic in March of 2020, the employer reopened the following fall. The employer testified they did not contact the claimant about open substitute assignments. Further, the employer has provided no evidence to establish assignments were available at the claimant's location. As the employer did not specifically contact the claimant and no evidence has been provided to show the claimant was directed to apply for the employer's assignments by the commission, the claimant is not subject to disqualification under the act. Affirm the AT suitable work eligible.
Reverse AT, suitable work disqualification.
Short form dissent.
Have you dissent, Commissioner Alvarez?
Case number-
One moment, please. Do you still wish to have the memo?
Yes.
Okay, we'll send the memo. Please proceed.
Case number 3081284, Commissioner Demerson.
We should modify the AT decision. First, I agree that the employer filed a timely appeal. Concerning the job separation, the employer's code of conduct forbid deceptive practices and required educators to be of good moral character. The commission in precedent case number 80-CA-77 found misconduct when the claimant's deception led to her absence from work. Similarly, here, the claimant was discharged when he requested time off for medical reasons, but thereafter deceived the employer by using the allowed time off for personal reasons unrelated to his medical condition. Since the employer's policy prohibited deceptive practices, the claimant's conduct of engaging in actions which failed to emphasize good moral character constituted misconduct connected with work. Hence, we should modify the AT decision, timely employer appeal, misconduct, no chargeback, adequate employer response.
The AT should be affirmed. Regarding timeliness, the record includes a timely appeal by the employer. Regarding the separation, the claimant was fired for how he spent his unpaid lunch break. On the day of the final incident, he had requested the afternoon off to see a doctor. The employer denied his request. They suggested he visit an urgent care facility during his lunch break. The claimant called the facility and realized that he could not complete the visit within his lunch break, which was a reasonable concern because the employer had denied his request for time off. The claimant then spent his lunch break with a coworker. The employer, who had followed the claimant on his lunch break, then fired the claimant for not having gone to the doctor. The claimant's changing his plans about trying to see a doctor under such time restrictions is not misconduct. Affirm the AT, timely appeal, no misconduct, chargeback.
Because the claimant was not under a duty to report his off-duty whereabouts to the employer, his failure to update his employer on his lunch plans was not misconduct connected with the work. Affirm the AT, timely employer appeal, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 311-7310, Commissioner Alvarez.
The AT decision should be reversed. The claimant worked at the assisted living community as a caregiver on an as-needed basis. The employer testified that the claimant quit, but the commission precedent in appeal number 96-009657-10-090297 directs us to consider whether a claimant took affirmative action to end the employment relationship. In this case, the claimant did not take any action to end the employment relationship. The employer discharged the claimant by removing her from their system after not worked a shift in the prior 30 days, according to their policy. But the claimant's not having worked shifts in the time prior to her discharge should not be considered misconduct. Reverse the AT, no misconduct, chargeback, and void adequate response.
The appeal tribunal decision should be modified. The employer stated that the claimant requested to be placed on PRN status. As such, the traditional PRN analysis of the claimant not knowing at the end of the day's work when the next assignment will be has no bearing on the premises. Regarding the separation itself, both parties agree that the employer's policy required PRN workers to take at least one shift during a 30-day period in order to remain employed. An employer witness also testified that the employer had texted the claimant multiple times asking her to work and to remind her about the 30-day rule. Nonetheless, the claimant failed to comply with the employer's policy. Accordingly, work-connected misconduct was established. We should therefore modify the AT decision, misconduct, no chargeback, sever the adequate response issue.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 311-8016, Commissioner Alvarez.
The AT decision should be affirmed. The claimant was discharged for an alleged violation of the employer's confidentiality policy for providing pay stubs to her supervisor, but the employer did not provide a copy of the policy. The appeal tribunal is in the best position to determine the credibility of the parties. The AT found the claimant's supervisor told her to prove other individuals were given time off, and she did so by providing the pay stubs. Further, both the claimant and her supervisor had access to the information as part of their normal job duties. Since the claimant was merely responding to the supervisor's direction and no parties received information to which they did not normally have access, the claimant was discharged for reasons other than misconduct. Affirm the AT, no misconduct, chargeback.
We should reverse the appeal tribunal decision. The employer's policy prohibited employees from accessing confidential records unless it was necessary to carry out an essential job function. Here, the claimant accessed confidential pay records for a personal reason. The employer neither instructed nor authorized the claimant to assess individual employee check stubs. Thus, because the claimant was on a 30-day performance improvement plan and thereafter violated the employer's policy, she mismanaged her position of employment. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3127424, Commissioner Demerson.
The appeal tribunal decision should be reversed on timeliness. The determination letter in question was sent to the employer during the window of time that TWC was encountering technical difficulties. As such, the employer's appeal should be deemed timely. Accordingly, we should reverse the AT decision on timeliness, timely employer appeal, resubmit for merits testimony.
We should affirm the appeal tribunal decision that the employer's appeal to the determination was late. The employer admitted to receiving the determination within a few days of its mailing. They voluntarily delayed appealing for over a year. The determination indicated that the employer's account would be charged as a result of the claim. The employer's misunderstanding of the chargeback language on the determination does not fall within the exception to the timeliness rule. There is no evidence that the employer received misinformation from the commission representative regarding their right to appeal or their chargeback to their account. And there is no good cause exception to the timeliness rule. The employer's appeal to the determination was late, and the original determination should be left in full force and effect. Affirm the AT late employer appeal, no misconduct, chargeback.
Reverse the AT, timely employer appeal, resubmit.
We will resubmit the case.
Case number 3131674, Commissioner Alvarez.
The AT decision should be reversed. The claimant properly reported to the employer that he was arrested on February 26, 2021 for a DWI offense. That charge was later dismissed on October 14, 2021. Before the DWI charge was dismissed, the claimant's scheduled ALR hearing was continued twice due to COVID. Instead of rescheduling the ALR hearing again, the claimant agreed to a license suspension and to the district court issued the claimant an occupational driver's license effective immediately on September 20th of 2021. The court ordered served as a temporary permit, and it directed the Texas Department of Public Safety to issue the claimant an occupational driver's license. The claimant's attorney submitted all the necessary documentation to DPS, which DPS received on February 27th of 2021. Nowhere on the court order did it state that it was only valid as an occupational driver's license for 45 days. The claimant did all he could to do immediately. The claimant did all he could to do by immediately submitting his documents to DPS, but through no fault of his own, DPS did not issue the physical license until January 4th of 2022. Therefore, the claimant was unaware he did not have a valid occupational driver's license and could not legally drive for the employer until the employer informed him after they ran an audit on their driver's license on December 31st of 2021. The claimant should not be punished for not having a valid occupational driver's license since he did everything he could to ensure that DPS issued the license within a 45-day time period. Since the claimant's separation was due to DPS's failure to process the occupational driver's license in a timely manner, we should find that the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
We should affirm the appeal tribunal decision. An occupational license is a special license requested by an individual after driving privileges have been suspended and requires a court order signed by a judge. It was the claimant's responsibility to know the terms of his occupational license and to follow up with any procedural requirements. By failing to notify the employer that his license was suspended and by continuing to drive for the employer when he was not legally authorized to do so, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct, reimbursing employer not billed.
Affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last case pulled for additional discussion on docket 20. You should have received the UI short form dissent list for docket 20.
I move we accept staff recommendations on the remaining UI cases on docket 20.
I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 20.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 20.
The motion passes with the exceptions noted.
Thank you. Continuing with docket 21.
Case number 2680420, Commissioner Alvarez.
The AT2 decision is not supportable. The claimant missed the AT1 and AT2 hearing because the notices of telephone hearing did not arrive at his address of record. A second copy of the notice for the AT2 hearing was mailed to his parents' address, but they were on vacation and the claimant did not have access to their residence. Since neither notice of the telephone hearings arrived at the claimant's address of record, he established good cause for the non-appearance at the AT hearings. Reverse the AT, good cause for non-appearance at AT1 and AT2 hearing, resubmit for merits testimony.
The appeal tribunal decision should be affirmed. The claimant missed the AT2 resetting due to circumstances that were within his power to control. Accordingly, the claimant did not establish a good cause for his non-appearance. As to the job separation, the available record supports the AT's finding that the claimant quit without work-connected good cause. We should therefore affirm the AT decision. The claimant did not have good cause for his non-appearance at the AT2 resetting. Leave the underlying decision in full force and effect. The claimant did not have good cause for missing the AT1 hearing. Voluntary leaving, no chargeback.
Reverse the AT, claimant established good cause for AT1 and AT2 resubmit.
We will resubmit the case.
Case number 2711531, Commissioner Demerson.
The commission should grant a rehearing in this case. The claimant received 25 weeks of severance pay in a lump sum that did not fall into any of the non-disqualifying categories of 207.049B of the Act. However, information regarding the date that the claimant received the severance pay is contained in her appeal to the commission, which has thus far not been entered into the record. Establishing the date that the claimant received a lump sum severance payment is critical for determining when the claimant's disqualification should begin. Accordingly, we should rehear this case so that the claimant can authenticate the documents she submitted in her appeal to the commission, and so that the same can be entered into the record.
The decision is not supportable. The employer provided the claimant with a lump sum severance payment in exchange for a release of claim and waiver of liability on July 23rd of 2020. The payment calculation included weeks in the formula, but the payment was not for any specific number of weeks and did not cover any specific period. As such, the claimant is only subject to a 1-week disqualification. Modify the AT severance not eligible July 19, 2020 through July 25th, 2020. Recalculate overpayment. If my fellow commissioners do not agree with a 1-week disqualification, the claimant has provided evidence showing the payment was not received until July 23rd of 2020. There is no evidence to indicate it was to cover any specific weeks. As such, the claimant's ineligibility should not begin until the week in which she received the severance payment. Modify the AT severance not eligible July 19, 2020 through January 16, 2021. Recalculate overpayment.
Modify the AT severance disqualification July 19th, 2020 through July 25th, 2020. Recalculate overpayment.
Right, we have not yet achieved a majority vote. We have 1 vote for rehear. And then the dates for the other 2 commissioners don't agree. The starting date of July 19th. Excuse me, did you say July 19th or June 19th?
July 19th.
Okay, then we do have agreement. It's a 1-week severance, July 19th through July 25th, 2020.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2740397, Commissioner Alvarez.
The commission previously voted this case on docket 41 of 2021. However, the underlying determination dated July 16, 2020 was improperly issued after a June 1, 2020 determination was final. Therefore, the prior commission ruling was improper. The commission decision, appeal tribunal decision, and July 16, 2020 determinations are void. The employer's original response was filed during the appeal deadline. Therefore, the commission should reinstate the original determination and issue a ruling on the record previously developed. The claimant had been working as a security guard without a license since 2014 and was unaware a license was required. The employer was purchased and the new management discharged the claimant because they did not legally employ him as a security guard without a license. The claimant's discharge was because of a state law and not for reasons of misconduct. The claimant should be entitled to benefits and the employer's account protected from charge. Grant MR, void commission decision, AT decision, and July 16, 2020 determination. Reinstate June 1, 2020 determination and affirm. No misconduct, no chargeback, operation of law.
I agree that we should grant the motion for rehearing based on procedural issues. I also agree that we should void the prior commission decision, the prior AT decision, and the July 16, 2020 job separation determination. The June 1st, 2020 job separation determination should be reinstated. However, this determination was issued before the deadline for the employer's response to the notice of claim had expired. The employer's timely response to the claim notice constitutes a timely appeal to the determination and considerations of merits testimony is appropriate. Regarding the job separation, because the claimant did not obtain a license as required and failed to provide information to the employer about the underlying reasons for his failure to obtain a license, the claimant was discharged for misconduct connected with the work. So we should grant the MR, void the prior CA and AT decisions, void the July 16, 2020 determination, then reinstate the June 1st, 2020 determination, and reverse the job separation to misconduct, no chargeback, adequate employer response.
Grant the motion for rehearing. Set aside the CA and AT decisions. Void the July 16, 2020 determination. Reinstate and reverse the June 1st, 2020 determination. Misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2834166, Commissioner Demerson.
The commission should grant a rehearing in this case. I do not contest the work search issue. Concerning the job separation, the claimant was discharged for violating the employer's policy by failing to report an accident. At the hearing, the employer testified that it could produce firsthand witness statements about the final incident, which led to the claimant's discharge. However, the hearing officer did not explore this. In addition, the record also shows that the employer had video evidence of the final incident. Since this additional information is crucial to adequately adjudicate this case, we should conduct a rehearing for the employer's firsthand witness statements and video footage related to the claimant's job separation.
The AT decision should be reversed. Regarding the separation, the claimant was discharged for being involved in an accident and failing to report the accident to the employer. The employer provided only secondhand testimony, while the claimant denied the allegations of misconduct and provided credible testimony that he was not involved in the accident. Since the claimant firsthand testimony was credible and the employer provided only secondhand testimony, the employer has failed to meet its burden to establish that the claimant engaged in actions that could not be considered misconduct connected with work. Regarding work searches, the claimant was required to make 3 work searches per week. For the week at issue, the claimant testified that he made 3 work searches, 3 work contacts for different employers by filling out online applications with those employers. The claimant provided specific information as to the names of the employers that he filled the applications for and the dates that the applications were submitted. Therefore, the claimant has established that he made the minimum number of required work search contacts for the BYE 4/17/2021. Accordingly, the AT decision should be reversed. Reverse the AT, no misconduct, chargeback, work search eligible.
Rehear.
We will rehear the case.
Case number 2856567, Commissioner Alvarez.
The AT decision is not supportable. The claimant had a job offer but needed to obtain a driver's license. He could not obtain the driver's license because the government office he needed to go to was shut down due to the pandemic. The job offer was eventually rescinded. Unemployment Insurance Program Letter 16-20 from the Department of Labor states that an individual is eligible for PUA if they are unable to start a job as a direct result of COVID-19 public health emergency. Therefore, the claimant should be held eligible for PUA benefits. Reverse the AT, PUA eligible beginning April 26, 2020.
Agree with that. The AT decision regarding the claimant's eligibility for PUA for a short time in early 2021 is supportable, but the rest of its decision is not supportable and should be modified. It's clear that the claimant's last work came to an end when it did because the aluminum pandemic supplied the final blow to an already faltering business. Thus, the pandemic caused a relevant work separation. Concerning his opportunity to work for another company in March 2020, his inability to secure anything other than a driving position was due to the pandemic, and so his continued lack of employment was tied to the pandemic. Finally, it's obvious from months of our own internal data on child care closures and limitations that what the claimant said about his daughter's inability to get into daycare during the height of the pandemic was also true. It would be a waste of time to hold another hearing just to confirm what our own information already tells us. Accordingly, we should modify the AT decision and find that the claimant was eligible for PUA benefits starting with the first date of his PUA claim, i.e. the claimant was eligible for PUA benefits beginning April 26, 2020.
Can you read that case number?
2856567.
Affirm the AT. PUA not eligible from April 26, 2020 to January 16, 2021. PUA not eligible beginning February 21, 2021.
Just to confirm the vote, Commissioner Alvarez, your vote is that the claimant is eligible with no ineligibilities starting April 26, 2020.
That's correct.
And that's your vote as well,
Mine is eligible for PUA benefits beginning April 26, 2020.
with no periods of ineligibility. It's just all open from
Right.
4/26 forward.
Yes.
Yes, sir. We have a majority vote that makes the claimant eligible beginning 4/26.
Short form dissent.
Yes, sir. Thank you.
Case number 2895647, Commissioner Demerson.
We should reverse the appeal tribunal decision on timeliness. Section 208.022B of the Act allows notice of an initial claim to be mailed to the location where the claimant last worked. However, this section does not reference determinations. The employer provided TWC its address of record in 2018. Despite this, the determination in question was not mailed to the employer's address of record, and the employer did not receive it. Because the agency failed to send the determination to the employer at its correct address of record, the employer's appeal should be deemed timely, and the case should be remanded for merits testimony.
On the issue of validity of claim, the evidence in the record established that the claimant filed a valid initial claim as an unemployed individual. On the issue of timeliness, the evidence established that the determination was properly mailed to the location where the claimant last worked. The employer's sole witness did not work at that location and was unable to provide credible and persuasive evidence sufficient to rebut the presumption of receipt. Furthermore, information in the employer's appeal indicated that the appeal was late because the employer had overlooked a determination. Because the appeal was filed after the appeal deadline, it was properly dismissed as untimely. Affirm the AT valid claim, late employer appeal, no misconduct, chargeback.
Reverse the AT, timely employer appeal, remand.
We will remand the case.
Case number 290.
One moment, please. Did you have a short form dissent, sir?
Yes, ma'am.
Thank you.
Short form dissent.
We have it. Thank you.
Case number 2906674, Commissioner Alvarez.
The AT decision is not supportable. The underlying issue in this case is whether the claimant worked customary full-time hours. This case involves the issue of validity of claim and therefore falls within the exception to the timeliness rules in Rule 32 I1. The claimant's AT appeal should be deemed timely and the case remanded for merits testimony.
The appeal tribunal decision on timeliness should be reversed. The underlying determinations in this case deal with customary full-time hours, which can be interpreted as a validity of claim issue. Such an issue constitutes a one-time exception to the timeliness rules, and we should reverse the AT decision on timeliness, timely claimant appeal, remand.
Reverse the AT, timely claimant appeal, remand.
Thank you. We will remand the case.
Case number 2913228, Commissioner Alvarez.
The decision is not supportable. The claimant was called a derogatory name 3 times by her supervisor in the presence of the claimant's trainee and other individuals. The individual over the supervisor had previously disclosed private medical information regarding the claimant's father to other employees. The employer HR representative was not available, and the claimant did not have anyone to whom she could report the incidents. The claimant had attempted to discuss the situation with others, but they avoided her and were too busy. The claimant had good cause to quit due to the derogatory name she was called, and the employer did not provide her a way to address the matter. Modify the AT, timely appeal, no voluntary leaving, no overpayment.
We should affirm the AT decision. First, I do not contest that the claimant filed a timely appeal concerning the job separation. Although the claimant alleged that she had discussed her work concerns with the direct supervisor, the claimant failed to provide evidence that she had adequately addressed her concerns with HR or talked to upper management about her working conditions. Since the preponderance of the evidence reflects that the claimant failed to address her concerns with the employer prior to quitting, the claimant's conduct constituted a voluntary quit without work-connected good cause. Hence, we should affirm the AT decision, timely claimant appeal, voluntary leaving, overpayment of $4,034.
Affirm the AT, timely claimant appeal, voluntary leaving, overpayment.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2955938, Commissioner Demerson.
In the context of the pandemic, the AT decision is not supportable. In prior cases in which an employer was faced with a large number of chargeback notices during the pandemic, each of which requires a timely response, I've argued that TWC failed to give employers an essential piece of information that would have enabled timely responses, even with the staffing shortage or other inability to deal with an overwhelming number of responses to submit, i.e. the option to submit one letter listing multiple chargebacks the company would like to protest. In my opinion, the omission of such crucial information is a form of misinformation that would qualify the employer, in this case, for the timeliness exception in Rule 815.32I7. That's Rule 815.32I7. This principle should apply to any claimant or employer whose ability to timely and effectively respond or appeal has been affected by such an omission in a determination or notice. I urge my fellow commissioners to agree with me that the employer should be considered to have filed a timely response to the notice of maximum potential chargeback, and that this case should be resubmitted on the question of whether the work separation will qualify the employer for chargeback protection. Reverse the AT decision and resubmit on the merits of the work separation issue.
The AT decision should be affirmed. The commission mailed the notice to the employer's correct address of record, and the deadline to respond was July 6, 2020. The employer admitted receiving the notice timely and also admitted to then filing the response late. The employer testified that the late filing was due to their staffing shortage, which is a circumstance completely under their control. At no time has the employer indicated that the late protest was because of misleading information or confusion statements issued by the commission. They have not offered any evidence of factors outside their control that caused the late protest, and there is no good cause exception to the timeliness rules. Affirm the AT late protest chargeback.
Reverse the AT, timely response to the NMPC, some resubmit.
We will resubmit the case.
Case number 2980292, Commissioner Demerson.
The appeal tribunal decision should be modified. First, I agree that the claimant filed a valid claim. As to the job separation, the claimant testified that the car in question was delivered to the shop on the Friday before the winter storm. The claimant further testified that he was terminated when he came back from the winter storm, despite doing his best to get the job done, given the time weather constraints. The employer testified that the final incident had to do with the specific car. Taken together, the parties' testimony indicates that the final incident resulted from the winter storm impacting the claimant's ability to meet the employer's requirement. As such, the claimant should continue to be qualified for benefits, and the employer's account should be protected due to the winter storm disaster. We should therefore modify the AT decision. The claimant filed a valid claim, no misconduct, no chargeback, disaster, void adequate response.
The AT decision is not supportable. The evidence in record established that the claimant's job duties had changed significantly around the time frame when he allegedly failed to meet the employer's production standards. The evidence further established that the final incident involved unavoidable delays resulting from a severe winter storm that caused power outages and transportation issues. As the employer did not meet its burden of providing that the claimant was discharged from misconduct connected with the work, the AT decision on work separation should be reversed. Modify the AT valid claim, no misconduct, chargeback, void adequate response.
Can you read back to me Commissioner Demerson's vote, please?
My notes say modify the AT valid claim, no misconduct, no chargeback, disaster, void adequate response.
I would concur with Commissioner Demerson.
Short form dissent.
Yes, sir.
Case number 2994780, Commissioner Alvarez.
The AT decision is not supportable. The claimant was fired for a technical policy violation because he did not report an accident to a supervisor. The accident in question was extremely minor damage to a Velcro strap that held a piece of plastic on a pole. The claimant told a team lead about it, who inspected the equipment. The claimant also told the team lead that he did not leave a radio to call that he did not have a radio to call his supervisor. Rather than call a supervisor as required under the employer's rules, the team lead told the claimant that he was okay to go back to work. The policy violation of which the claimant has been accused of is so insignificant as to be frivolous. The claimant's action clearly did not rise to the level of misconduct connected with the work. Reverse the AT, no misconduct.
Should affirm the appeal tribunal decision. The claimant admitted that he did not report an incident to a supervisor at the time the incident occurred because he believed the supervisor was at lunch. However, the claimant did not explain why he did not report the incident upon the supervisor's return. Thus, because the claimant failed to report an incident to a supervisor as required by policy, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct.
Reverse the AT, no misconduct.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 301-3715, Commissioner Demerson.
We should grant the employer's motion for a rehearing. The employer in its motion for a rehearing provided that a firsthand witness was now available to testify on the employer's behalf. This witness was not available to testify earlier because she was employed by the client company at the time of the AT hearing, but is now employed by the employer and is available to testify. In addition, the record reflects that the employer's witness conducted audits on the claimant's work and could attest to the claimant's falsification of records, which led to the claimant's separation. Testimony from this witness would thus change the outcome of the case. Because the employer has met the 3 required criteria, we should grant the employer's motion for rehearing.
The motion for rehearing should be denied. The employer has not provided a compelling reason as to why testimony from its proposed witness could not have been presented at the AT hearing. Therefore, the employer has failed to satisfy the criteria for granting a motion for rehearing pursuant to Commission Rule 17. Deny the motion for rehearing.
Deny the motion for rehearing.
Maintain my previous dissent.
Yes, sir, Commissioner Demerson.
Case number 302-7120, Commissioner Alvarez.
The decision is not supportable. The claimant was a self-employed individual whose business declined due to the pandemic. The claimant ultimately had to close the business due to the decline. The claimant has met the requirements for PUA benefits. Reverse the AT, PUA eligible.
The AT decision is unsupportable. The claimant's testimony at the hearing established that he had to close his business during the height of the pandemic, June 2020, because people just stopped coming around. To pretend that the closure at such time was not related to the pandemic is to ignore the reality of running a small business at the time. Accordingly, we should reverse the AT decision. The claimant was eligible for PUA benefits beginning November 8th, 2020.
Affirm the AT, PUA not eligible beginning November 8th, 2020. Short form dissent.
Yes, sir.
Case number 304-1220, Commissioner Demerson.
The appeal tribunal decision should be modified. First, I agree that the claimant filed a valid claim. Concerning the job separation, the claimant's discharge resulted from her failure to take the COVID-19 vaccination. The commission should take administrative notice of the claimant's fact-finding statement where she alleged that her refusal to take the vaccination arose from circumstances related to her medical condition. Since the record shows that the claimant's separation stemmed from a medically verifiable illness, the claimant should be qualified for benefits and the employer's account should be protected from charge. Hence, we should modify the AT decision, valid claim, no misconduct, no chargeback, MBI.
Ms. Miller, I would agree with Commissioner Demerson.
Modify the AT, valid claim, no misconduct, chargeback.
You wish to short
Form dissent.
on the chargeback issue,
Yes.
sir. Thank you.
Case number 305-4918, Commissioner Alvarez.
The AT decision is not supportable. The claimant quit the job because she had multiple problems getting paid correctly by the employer. In the first incident, the employer did not pay the claimant in the correct method that the claimant chose when she started the job, and she never received the debit card that held her wages. Later, the claimant was not paid for time that she spent with technical support trying to fix problems with the employer's computer system. The claimant made extensive efforts to resolve the problems, but they were not addressed. The claimant quit as a result. She therefore had good cause connected with the work to resign. Reverse AT, no voluntary leaving chargeback.
We should affirm the appeal tribunal decision. Although the claimant may have had a legitimate complaint by quitting without giving the employer a reasonable opportunity to remedy her concern, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Reverse AT, no voluntary leaving chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 3111596, Commissioner Alvarez.
The claimant was laid off and the employer informed her it was due to COVID. This is sufficient to establish PUA claim. The claimant is eligible for PUA benefits. Reverse AT, PUA eligible.
There is sufficient evidence to support the AT decision. The available information indicates that the claimant was laid off from a short-term temporary assignment in which she was needed to fill in for other absent employees at the U.S. Postal Services. When sufficient number of the employees returned from the leave, the claimant was no longer needed. Thus, the claimant's work separation appears to have been more in nature of a traditional layoff than one that was directly caused by the pandemic. Accordingly, we should affirm the AT decision. The claimant was ineligible for PUA benefits beginning January 3rd, 2021.
Affirm the AT, PUA not eligible beginning January 3rd, 2021.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3112523, Commissioner Alvarez.
The AT should be reversed. The claimant worked as a chemical operator. He was fired because of a leak that occurred at a plant where he worked in partnership with another employee. In sworn testimony, the claimant denied having opened the valve which caused the leak. The claimant testified that he was terminated under the employer's HERO policy, which holds that both partners are responsible for accidents that occur during their shift. The employer did not provide any information to the agency, neither a response to the notice of application nor an appearance at the hearing. The only evidence in record is that the claimant's sworn denial of action which caused the leak. Therefore, the record shows that the claimant was discharged for reasons other than misconduct. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant and his partner failed to close a chemical valve, thereby causing a chemical leak. While it's unclear if the claimant was the person responsible for the failure to close the valve, under the employer's policy, the claimant and his partner were responsible for double checking each other's work to prevent safety violations. Because the claimant had previously been written up for not checking his partner's work, he mismanaged his position of employment when he failed to ensure that the valve was properly closed. Accordingly, we should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3112768, Commissioner Alvarez.
The AT decision should be reversed. The claimant quit this employment as a custodian for medically verified reasons. Prior to quitting, the claimant had used FMLA leave after having foot surgery. But after returning from leave, she continued seeing doctors for ongoing knee problems, knee injuries. Although she was available for work, she quit because of her ongoing injuries, which is not disqualifying under Texas Unemployment Compensation Act. Reverse the AT, no voluntary leaving, bill reimbursing employer.
We should affirm the appeal tribunal decision. The claimant quit after a medical procedure, even though she was released to work without restrictions and no doctor advised her to quit. Under these circumstances, the claimant is considered to have quit without good cause connected with the work. Accordingly, we should affirm the AT decision, voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3122123, Commissioner Demerson.
The appeal tribunal decision should be modified. The claimant was discharged due to absences resulting from delays in getting COVID-19 testing results. Since the delays in getting the testing results were not the fault of the claimant, and since it is not unreasonable to conclude that the employer has a safety interest in maintaining COVID-19 protocols, the claimant should continue to be qualified for benefits, and the employer's account should be protected from charge due to the disaster. We should therefore modify the AT decision, no misconduct, no chargeback, separation due to disaster.
Ms. Miller, I would agree with Commissioner Demerson.
Modified AT, no misconduct, no chargeback disaster.
Thank you. Have unanimous decision.
Case number 312-7320, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant was discharged for being a no-call, no-show on a night that she was scheduled to work. While unfortunate, the events that led to the claimant being a no-call, no-show were due to forgetfulness and not due to any readily apparent circumstances beyond the claimant's control. The claimant also admitted that when she incurred her first no-call, no-show, her supervisor verbally told her that it should not happen again. As such, the claimant's actions amounted to work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
The AT decision should be reversed. The claimant was discharged for a no-call, no-show absence. The claimant, however, established a compelling reason for failing to notify the employer that she would be absent because she did not have access to her phone or a car to notify the employer. Her actions therefore did not rise to the level of misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3133917, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer has a firsthand witness to the meeting that took place with the claimant. However, according to its appeal to the commission, the employer's witness was unable to participate due to being out of the country at the time of the hearing took place. The meeting that occurred with the claimant is a critical event to this case. As such, we should hold a rehearing for testimony from the employer's firsthand witness.
The AT decision is correct. During a meeting on January 20th of 2022, regarding a statement that the claimant made in December of 2021, the claimant asked if it was his last day. After returning to his office, the employer informed him they were accepting his resignation. Both of the employer's witnesses testified that they were not of the opinion that the claimant was quitting following the meeting. The employer has not provided evidence of misconduct, and the claimant's question of whether he was employed is not misconduct. Affirm the AT, no misconduct, bill reimbursing employer.
Rehear.
We will rehear the case. And that was the last case pulled for additional discussion on docket 21. You should have received the UI short form dissent list for docket 21.
I move we accept staff recommendations on the main UI cases on docket 21.
Chairman, I second the motion, except for those cases on which I'm dissenting as reflected on UI short form dissent list for docket 21.
Now I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 21.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. This brings us to the end of agenda items 3 through 7. We'll take a short break. We're back with agenda item 8, non-LEU based period employers.
Good morning, Commissioners. Nelson Kerr with the Office of General Counsel. Before you today is a discussion paper that was requested by this body several weeks ago on the possible means for offering non-LEU employers an opportunity to obtain a ruling from the agency on chargebacks to their account where the employer did not timely submit a protest or appeal during the COVID event. I don't have anything else in my presentation, but I'm available to answer any questions you may have.
We do have a public comment. If I could ask you to sort of hold on, let's
Yes,
hear
sir.
from the public and then we'll come back and address any questions we may have.
Commissioner Celeste Trubman, we do have one commenter. Ms. Strufert, if you could go ahead, unmute yourself, introduce yourself for the record and proceed.
Hi, hopefully you can hear me.
Yes.
Great. Good morning. My name is Kelsey Erickson Streufert. I'm the Chief Public Affairs Officer for the Texas Restaurant Association. The TRA represents restaurants of all shapes and sizes from across our state. We're the second largest private sector employer. And as you know, our industry has been especially devastated by COVID-19. We were under full or partial closure orders for nearly 1 year, and now supply chain disruptions, inflation, and labor shortages have made it nearly impossible for many to break even, much less recover from the past 2 years. The good news in all of this is that the TWC has been an incredible partner to our industry throughout the entire pandemic. Thank you for all that you continue to do to support restaurants' recovery. I'm here today to quickly ask for your support of agenda item 8 on today's agenda. I've heard from many restaurants who saw their unemployment insurance tax rates jump from the lowest possible rate to the highest in the past 2 years because of COVID claims they didn't know they would be held responsible for. In the chaos of the early days of the pandemic, many restaurants believed they would not face chargebacks for any of these COVID claims because of TWC communications. Some never received their notices, others received them but couldn't connect with someone at the TWC to understand their options. We provided guidance working with your wonderful staff at the TWC, but those days were truly unprecedented and everyone was doing their best to simply survive. Adopting agenda item 8 and giving employers a fair chance to quickly and efficiently protest or appeal COVID chargebacks will go a long way towards helping restaurants get back on their feet. For the most part, these are small businesses and they want to do the right thing. They just need some help navigating the system so they don't have to pay significantly higher taxes than they should. At this point in their recovery, I can assure you that could mean the difference between a small business being able to stay open and rehire or not. Thank you again for considering this proposal and for giving me the chance to speak today. And again, thank you for being such a great partner to our industry.
Thank you. Any comments or questions for Nelson?
Yes, Chairman, I have a comment. I'm not in favor of this proposed modification to the chargeback process. In the current system, employers are given the required notice of chargeback to their account and already have multiple opportunities to protest and have their case adjudicated if they believe that their account has been wrongfully charged. There is no evidence that employers in Texas face an undue burden because of their employment tax contributions or account charges. During the pandemic, most employer appeals on chargeback and timeliness have not been based on allegations of misleading information or other failures by the commission. Rather, their appeals are based on many of the same struggles, meeting commission deadlines and procedural requirements that claimants have faced during the pandemic, for which they have not been afforded any specific treatment, any special treatment such as this. My understanding is that the majority of the chargeback complaints have come from third-party administrators whose business it is to respond to UI claims. Unlike Hurricane Harvey, where there was devastating infrastructure damage, the pandemic caused no infrastructure damage. Fax lines, telephone lines, internet all remained operational. Businesses pivoted, and adapted. Recently, the commission took action to establish a replenishment tax rate comparable to the rate employers had to meet prior to the pandemic. The Texas legislature approved $7.2 billion to add to the UI trust fund so that employers would not be subject to increased tax contributions. Analysis presented by staff indicates that the proposed action could cause pressure on the UI trust fund within 1 to 2 years, even if future UI claims are within a normal expected range. However, there are serious reasons to believe that the unemployment claims may not stay within their current projected trajectory. There are credible economic indicators that we may be heading into a recession in the near future. We will also enter hurricane season, and we all have seen the devastating effects summer wildfires can have on our state. Any of these potential disasters could cause an increase in unemployment. If there is a drastic rise in UI claims, we might not have the flexibility to maintain the current low tax rate. Taking this action today may force us to raise the tax rate on employers down the road, when an increase might most stifle recovery. We must prepare for what lies ahead. Staff has presented information that implementing this option would cause significant increases to investigative and appellate divisions on top of existing backlogs and will negatively impact our DOL time lapse numbers and cost the agency an additional $6.1 million to contract personnel costs, TWC personnel costs, and other costs. Given the risk and cost involved, we cannot afford to approve this action. The current process has been well tailored over time to judge the merits of each party's claim meaningfully and accurately on case-by-case basis. We should not do anything here today to disturb that balance. For these reasons, I do not support this proposal.
First of all, let me thank Kelsey, who just testified in the Texas Restaurant Association. I appreciate the relationship that we have with them, and Nelson, you and the team. I appreciate all the hard work that's been put into this request, as well, the entire staff, legal side, finance side, the entire team. And so Randy, make sure that Ed knows we appreciate that support. The action we're taking today is very meaningful for employers, some of whom may have genuinely thought that they did not need to respond to chargeback notices that were issued during the height of the pandemic. I welcome the opportunity for affected employers to have a reasonable opportunity to submit responses and explain any circumstances that would allow otherwise late responses to be evaluated. The important thing will be that we have a reasonable opportunity to submit responses and have their chargebacks evaluated on the basis of why particular employees stopped working for the companies whenever they did. So we look forward to further discussion.
Let me offer a motion. I move we approve the publication of the opportunity for non-last employing unit-based period employers who received chargeback determinations during the pandemic to file an appeal or protest, provide an explanation of the reason for the late filing, and receive a decision or determination that may be appealed for a hearing on the matter as described in the discussion paper presented by staff.
Mr. Chairman, can I add a
Certainly.
friendly to that? If we were able to add some dates and parameters around that, those that have not already responded to the notice of maximum potential chargeback that were sent to them during the period between and including the dates of March 2nd, 2020 and December 31st, 2020, that they may respond within 30 calendar days of the mailing date of the announcement and explain the circumstances of their responses and of the work separations underlying the chargeback notices, and that any issues of timeliness and chargeback of benefits will be determined on the basis of Commission Rule 815.32, the timeliness rule, in Section 204.022 of the Texas Labor Code. That's the chargeback protection code. So we're basically putting in the record just some parameters and timeframes around that.
What was your time frame?
So the dates, again, were including the dates of March the 2nd, 2020 and December 31st, 2020.
And then what was the remainder of that?
And that they may respond within 30 calendar days of the mail-in date, and the rest was in line with what you had already mentioned. So it's basically your motion, but putting some parameters around it with dates.
So your reference to Administrative Code, Chapter 815 would just simply mean that under this process, employers would be bound by the existing rules on appeals and timeliness?
Yes, that if we're accepting this motion, that we would refer back to the Commission Rule 815.32, and then
Which I think was staff's intent, and
Mhm.
certainly it was mine as well. So
Yeah.
really the substantive amendment you would make to my motion is to bracket that between the dates of March 2nd, 2020 and December 31st, 2020. So any notice that they received during that time, if they assert the correct affirmative sort of defense of why they didn't respond during that time period, they could make their protest. Is that what I'm hearing?
that's correct.
Yes. Very good. Just to clarify it, the addition of the 30-day requirement for response is a change to what you had proposed initially and not necessarily addressed in the original DP.
So you're talking about the dates?
Not the limitation, well, the limitations on dates certainly are amendments as well. They weren't contemplated by the original discussion paper, nor would the 30-day period of response after the announcement have been something that was vetted previously.
So the proposal, the staff proposal, what would have been the response time for that?
There wasn't a limitation on either response time or the period in which the
Right.
individuals were covered.
Mr. Chairman, I think the additional time frame or parameters, let me ask you, can I ask?
But by all
Yeah,
means.
Would parameters assist the staff in if this effort were approved, would having parameters assist the staff?
Bounding the period where it might be applicable certainly would have some effect. I can't speak to whether or not bounding the period in time in which they would have to respond would have a similar measure, given the timings of the delays that have already occurred.
Yeah, so if we allowed it past 30 days, is almost perpetual in a sense.
Potentially, that would be the case. There's almost always an opportunity when you're looking at the timeliness rules to look at when an employer actually received notice of an opportunity and to use existing precedent to address their failure to act once they had specific notice. But that's not something that would necessarily specify, well, if they're on the 32nd day, that they're outside of that opportunity.
So as it exists now, it's pretty much wide open.
The existing DP does not set parameters. That's correct. I'm not saying that parameters couldn't or shouldn't be set, but they're not discussed.
Yeah, and Chairman, that's the reason for the parameters that I've indicated here. I don't think anything that I've suggested is could be hard, felt to be hard pressed on either employers or the staff from that point.
So, I mean, just in terms of my motion, I would, I see the logic behind the March 2nd, 2020 through December 31st, 2020 timeframe, and I could certainly accept that as an amendment to my motion. I'm not inclined to accept the amendment with regard to the time in which they act. I think we've got to give some adequate time here. A lot of time, I mean, there were restaurants that were closed for some large period of time that we heard from the witness with regard to the pandemic. There were other businesses for whom this would impact. I do think, reluctantly, but I do think that the timeframe March 2nd through December 31st probably does capture most of the employers who might have seen information that we published in some way, found confusion in that and failed to make a timely sort of response. And my interest is in helping those employers who felt like they had one piece of information, acted in another way, and didn't get all of their rights that they could have enjoyed here at TWC. So I think that the limitation of the dates March 2nd through December 31st really probably does create a universe of all employers who may have been subjected to this misinformation. I don't see the benefit of the second part to your amendment in terms of why the need to rush it through during that time period.
Yeah.
I would also, I'm sorry, I would also suggest that, by leaving in slightly more flexibility, staff has more room to work through what could be, has the potential to be an influx of workload, but that's sort of a secondary thought in my thought process.
Okay, now I'm fine with without the 30 days. I think we were just trying to keep in line with what we already do in terms of responses. The 30 days, that's pretty standard. And so that's where we're going there. This is a unprecedented situation. And so I'm not hard pressed on that. I just wanted to offer that as an amendment just in case and wanted to hear staff's thoughts on that as well. The dates are fine. And if we're going past 30 days, then we're going past 30 days. And so I'm not hard pressed on that.
Some before we
Yeah,
vote.
I
we
was going
got-
to ask you a question, but please. go
Yeah,
ahead.
it's because a lot of stuff came up and actually really good points. So one is, Nelson, is there any basis in the rule to limit the time frame?
The rule wouldn't necessarily specifically limit the time frame,
Okay,
nor would we have anything that we could point to in rule that would specifically support creating a limited time frame. That would be something that would be part of the operational process, not necessarily something that we would be able to point to rule and say, oh, well, because we've sent a new opportunity, that creates some deadline to respond. We're not attempting to, let me clarify. The discussion paper doesn't attempt to create a new right. It intends to notify employers of an existing right to use existing processes to assert their rights, even though they may believe that they no longer have that opportunity. And then they would have to explain the reason for the delay and then have an adjudication of both that reason for delay and the underlying chargeback.
I can, Commissioner Alvarez, maybe I'll have other questions,
Yes.
but I want to ask about that point that you just made. That part's incumbent on the process that you've laid out. The employer has to make the assertion that they somehow missed this due to misinformation or a confusion of information or something like that. They have to have some valid reason for not having made the protest and or appeal at the appropriate time.
That's correct.
Okay, I'm sorry.
and we're not acting outside our authority, right?
Based upon the information that's been presented in the discussion paper, if they are required to provide that reason to establish jurisdiction within the agency and the commission, no, we're not acting
Okay.
outside of our authority.
You know, some good comments were made from the dais. I have another question. I know it's not a part of the discussion paper. Would this apply to claimants as well?
Would it apply to claimants?
Yeah, because we're talking about employers. I'm just curious.
Sure. I'm not certain in which cases it would arise, but certainly if there were claimants that had received information from the agency that they felt in some way misled them about their opportunities or rights, they'd be able to make the same presentation as an employer would be making under this discussion paper.
Interesting. All right. So a lot of stuff has been given to us. Chairman, I'd be willing to reevaluate this and have this presentation again at a later next commission meeting. It's up to you all. I mean, this is some really good information and I'm actually inclined to a lot of the things that you all have said from up here.
Chairman, I'm prepared to take action today.
What would be your interest in delaying action?
Just for clarification, I mean, you just stated something here about the claimants. That's fairly interesting to me. I like that. I like the idea of being able to actually use the same type of discussion to include my claimants. I guess it really would be how it's going to impact the agency.
Correct.
You know, that's what really concerns me, as you heard in my comments regarding what we're going to, or at least we're seeing in the future that we may encounter as far as natural disasters and stuff. So I'm just curious. I just want to know specifically how it would impact the agency.
With respect to, and I apologize for
No, that's
having
fine. No.
divided attention. With respect to the rules on timeliness, they're not specific to any specific party.
Okay.
So where an individual makes a representation about the timeliness of their response to agency action, it doesn't make any distinction between whether it's an employer making that representation or whether or not it's a claimant making that representation. For notice purposes for today's discussion paper and action, this has been noticed as an employer specific. So if we were trying to expand that to include claimants in some way out of this, we may have to renotice it in order to have the adequate notice to the public that we're not looking at specifically what they were originally advised.
Chairman, I know you put a lot of work in this with the trust fund and all of that. And I'm just going back to some of the remarks that were made some time back and how important it was, but I certainly understand the position that we're in with this.
Well, here's my stance today. I think I'm hearing that Commissioner Demerson and I agree that we would move forward on staff's proposal with the addition of the March 2nd, 2020 through December 31st, 2020 brackets. It's a legislative term, but I'll use it here. On the other hand, Commissioner, you present a compelling case. Since we have two commissioners that seem to be in agreement, I would say that if indeed we agree on this, that the commission would take this action today. And then I think you do make a compelling point, and I would ask staff to go through the same evaluation procedure that they did on this known employer issue with regard to claimants, and see if there is a pool of claimants who were similarly impacted, who might find similar relief, which would give us time to do the type of due diligence that it would appear staff did on this one, since they presented to us some pretty lengthy information. So what I'm suggesting is that if indeed Commissioner Demerson and I agree, and I think that we would take an affirmative vote today. You would vote however you choose, obviously. That would be the commission action, but then I would ask staff to bring back a similar analysis of claimants and see what that situation looked like.
And that would include, Chairman, the same dates that you all referenced earlier, the March 2nd, 2020 to 20.
Probably. I mean, it's a
Okay.
good time frame for us to look at. I think so.
Commissioner Alvarez, I think when we were just going through all the discussions, we were under the impression or thinking that claimants would probably, it will be on both sides.
Okay.
But it's in here as employers right now.
So the question before us is my motion with the addendum of the March 2nd, 2020 through December 31st, 2020 timeframe, for which employers falling within that timeframe could avail themselves of this action. So I'm prepared to vote aye, and am voting aye. Commissioner Demerson.
I've second that motion and vote aye.
Commissioner Alvarez.
So I'm going to abstain from this particular item today until we defer a vote, until we just, I like what the chairman said about the claimants, and Commissioner Demerson, it was always the impression that we were going to include the claimants as part of this discussion. So I'm just going to go ahead and abstain for today's vote on this particular agenda item.
Okay, so the vote today would be 2 ayes, 1 abstention.
Mhm.
And then protocol, Mr. Townsend, if you would be so kind as to ask staff to prepare a similar analysis for claimants following the same model that we just did for employers, and bring that back at the next available commission meeting. I really would appreciate that.
Good idea.
Thank you.
Mhm.
Thank you, Mr. Kerr.
Thank you.
This brings us to agenda item 9, PPD Advisory Committee Chairperson.
Morning, Commissioners, Mr. Townsend, Juan Garcia with the Voc Rehab Division. This morning, for your consideration and possible action, we are bringing forth the appointment of a chairperson for the Advisory Committee of the Purchasing from People with Disabilities Program. Section 122.0057A of the Texas Human Resources Code authorizes the Texas Workforce Commission's 3-member commission to form an advisory committee to help establish program performance goals and criteria for certifying community rehabilitation programs for participation in the Purchasing from People with Disabilities Program. Section 122.0057B states that the advisory committee members must be composed of 13 members appointed by the commission as follows: 4 representatives from CRPs that participate in the PPD program, 4 representatives from organizations that advocate for individuals with disabilities, 4 individuals with disabilities, 2 of whom are employed by CRPs that participate in the PPD program, and the executive commissioner of the Texas Health and Human Services Commission, or his or her designate. Section 122.0057D requires the commission to appoint an advisory committee chairperson from among the members serving on the committee. When the role of the chairperson is vacant, PPD staff invites current PPD members to submit their interest in serving as chair. PPD staff members then gather information about each interested member and consider factors such as the opportunity for a member of each group representative on the committee to serve as chairperson, and the experience of each interested member in performing similar leadership roles. Following the completion of the former PPD Advisory Committee chair's term, PPD staff surveyed committee members to determine which members were interested in being considered for appointment as chairperson. 2 members, both of whom represent CRPs, expressed an interest in serving. Staff recommends the appointment of Mr. Platt Allen as chairperson of the PPD Advisory Committee for a period beginning May 24th, 2022 and ending February 1st, 2025. With that, I can answer any questions.
Any
you might
questions or
have.
comments?
None here, Chairman.
None here.
Is there a motion?
Chairman, I move that we approve appointing Mr. Platt Allen as chairperson of the PPD Advisory Committee for the period beginning May 24, 2022 and ending February 1st, 2025.
A second.
It's been moved and seconded and we're unanimous. Thank you.
Thank you.
This is agenda item 10, a policy concept having to do with chapter 801 LWDB rules.
Hi, good morning, Commissioners, Mr. Townsend. For the record, I'm Joel Mullins with the Workforce Development Division. Today, for your consideration, is a policy concept relating to potential rule amendments to Chapter 801 on local workforce development boards. The proposed changes are related to WIOA conformity, local board required partnerships, the veteran definition, digital skill building, and financial literacy. Additionally, the rules in Chapter 801 will be reviewed in accordance with Texas Government Code Section 2001.039. This morning, staff seeks direction on this policy concept for potential rule amendments to Chapter 801 as detailed in your meeting materials, and I'll be happy to answer any questions.
Any comments or questions?
None here, Chairman.
None.
Is there a motion?
I move that we approve the policy concept to amend Chapter 801, local workforce development boards as recommended by staff and described in the discussion paper to be posted to the commission website for an informal 30-day comment period.
A second.
It's been moved and seconded. We're unanimous.
Okay, thank you.
This is agenda item 11, a policy concept, chapter 803 skills development fund rules.
Okay, good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, my name is Abby Austin with the Outreach and Employer Initiatives Division. Commissioners, before you today for your consideration for approval is a policy concept to amend Chapter 803 Skills Development Fund. This amendment will streamline the grant proposal and approval process. In fiscal year 2020, the Texas Workforce Commission implemented Skills Development Fund COVID-19 grants to respond quickly and effectively assist the COVID-19 recovery effort. The agency designed COVID-19 grants to help Texas employers, including small businesses, train and hire employees, excuse me, while simultaneously supporting Texas workers in regaining employment and reducing the number of individuals depending on unemployment assistance. In 2021, we expanded the pilot to SDF grants that continue to support economic recovery through skills training for Texas businesses. The new process has proven to be successful in streamlining the SDF approval process and shortening the grant development time by saving anywhere between 40 to 50 days. The Outreach and Employer Initiatives and Office of General Counsel have developed a waiver for the rule pursuant to 40 Texas Administrative Code 803.32 for approval by TWC's Executive Director to use this new process. The proposed rule will remove the need for a waiver and allow for the use of this streamlined process moving forward while still allowing for traditionally developed contracts. Texas Government Code 2001.039 requires state agencies to review their rules at least every 4 years. This rulemaking will satisfy that statutory requirement. Staff recommends amending Chapter 803 to expand the grant proposal and approval process to allow for the streamlined method and reviewing the chapter in accordance with Texas Government Code 2001.039. This concludes my presentation, and I'm available to answer any questions that you might have.
Comments or questions?
None here, Chairman.
Have you got good presentation, good job. And anytime we can streamline processes that benefit employers in that regard, it's a good thing. So appreciate and applaud the staff on those efforts.
Thank you.
Is there a motion?
Chairman, I move that we approve the policy concept for Chapter 803 Skills Development Fund and post to the TWC website for an informal 3-week comment period.
Second.
It's been moved and seconded. We're unanimous. Thank you. Agenda item 12 has been postponed to a future commission meeting. This is agenda item 13, apprenticeship funding.
Good morning, Commissioners and Mr. Townsend. For the record, Carrie Ballast of the Workforce Development Division. For your consideration today is the fiscal year 2023 planning estimates for the apprenticeship training programs. Each year, the Texas Workforce Investment Council makes recommendations regarding the Chapter 133 apprenticeship training program. This year, TWC's recommendations are as follows: a contact hour rate not to exceed $4.25, and a 5% reserve for new programs or established programs that have not that are not currently receiving funds. So for today, your commission decision points are as follows: a planning estimate that is detailed in your notebook materials, and acceptance of the TWC recommendations. As required by Texas Administrative Code Rule 837.21, with the commission's approval, we will provide public notice of the amount of the funds available to support apprenticeship training programs for FY23. That concludes my remarks. I'm happy to answer any questions.
Comments or questions?
None here. Thank you, Karen.
I have a couple of questions. Can you clarify for me how the funds from this program are distributed to grantees? Like, how do they sign up to get these funds?
Upon notice of the funds being available, we have programs who will contact and go through an application process with our Apprenticeship Texas team. They, over the summer, will submit estimated number of apprentices that they will train over the year. We then put a contract in place with them based on those estimated amounts. A little bit later into the year, when our programs know the exact number of apprentices to be trained, they submit an amendment and we amend the contract to reflect the actual number of apprentices trained.
How are those applications evaluated?
As of this point, they meet the requirements of being a registered program with DOL, that they have an apprenticeship committee in place, that they are acting as an LEA, a local education agency, or as the apprenticeship committee itself. If they meet those requirements at this point, and if funding is available, we've been able to meet all of the contract requests that we receive.
So it's just sort of a first come, first serve situation right now, based on whether or not you meet the requirements.
Yes, sir.
Do we turn very many applications away?
To date, no, sir, we do not.
No. If, would we ever consider a point where it'd be a more competitive type application?
Yes, sir. We do in our rules note that the commission is able to adopt performance requirements. If, for example, in the future, we receive so many applications, we began to become concerned about maintaining a contact hour rate that would work well for these programs, we could put in some performance standards and then begin to select applicants based on previous performance.
And I just want to clarify for myself. So we have exactly the number of applications that we have dollars available, or we don't fund all, we have dollars left over. Just help me clarify that.
Yes, sir. In the funding that we set aside, part of that is general revenue. The other part is we owe statewide. Based on the number of apprentices that we're able, that are served, we typically adjust the WIOA state balance up and down to meet that. At least the commission, as you know, strives to meet about a $4 contact hour rate each year. So that balance is adjusted up and down to meet that $4 rate. In previous years, I believe for the last couple of years, we have had a little bit of a WIOA statewide balance left at the end of the year.
But we're close. I mean, like, we're close on
Yes,
this.
yes.
Yeah, I asked for two reasons. One, we've introduced some new apprenticeship concepts in the last 60 days or so that are taking form. We've you guys have done a remarkable job at creating new apprenticeship programs with some expansion grants that we've had. I'm trying to, in terms of good governance, try to pinpoint a date in the future where there would be more competition for the funds, and we might possibly have applications that would exceed the amount of funds that are available. And that's the picture that I'm trying to get. My next question is related to that. So that being the case, is the 5% set aside for for new apprenticeships or people who haven't otherwise used the funds. Is that a fail safe at this point, or is that something that gets exercised pretty aggressively each year?
It's fail safe at this point.
Okay, all right. I don't have any other questions, comments. Anything else, gentlemen?
No, great presentation, Kerry.
Thank
Thank you for
you.
the answers.
Yeah, is there a motion?
I move that we approve the apprenticeship training program funding for fiscal year 2023 as follows. A planning estimate of $3,732,785 in general revenue, $1,650,000 in WEO statewide, $150,000 in TANF NCP funds for fiscal year 23 registered apprenticeship funds, contingent on adoption of TWC's fiscal 23 operating budget, a fiscal year 23 contact hour rate not to exceed $4.25 an hour, a 5% reserve of planning estimate funds for new or established registered apprenticeship training programs that did not receive Chapter 133 funds in fiscal year 2022.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
Nothing on agenda item 14, nothing on agenda item 15, nothing on agenda item 16. There is no legislative report today. Mr. Townsend.
Morning, Chairman.
I do not see Mr. Cerna in the audience, so we
Okay, so
can
I'm in
speak
the free and
frankly.
clear here. All right.
All right.
I do have a couple of reports to offer this morning. I'll start with the request, Chairman, that you'd made back on April 26th, where you had requested that staff bring back a plan regarding a couple of items. One of those items was any potential limitations on eligibility of the public sector healthcare workers for being included in our programs. And the second were any steps the commission would need to take to eliminate barriers to participation. So those are the questions that will be addressed in the report this morning. I'm going to focus on the apprenticeship and the skills development this morning. As far as the information, those are the two of the programs thought could benefit the public sector healthcare employers in our case. As we identify other programs, however, we plan to bring those back to the commission and include recommendations for the future. Before I go into the discussion on the apprenticeship and the skills development, I just want to make clear one item, just so there's no confusion around this. And that is the initiatives that were previously that are being funded with the federal apprenticeship expansion funds, which includes the recently approved statewide health care apprenticeship initiative, do not currently have limitations on the eligibility of public health care workers. So what that means is that TWC is not restricted in working with public versus private employers when using the federal apprenticeship expansion grant dollars. And then also it means that support for both public and private employers in the state can be supported in the statewide healthcare apprenticeship initiative. So I just want to make sure that that point was clear before I go provide a little bit more information about the apprenticeship and the skills here. With respect to apprenticeship program, there is a term apprentice that is in the definition in the Chapter 837 rules for the apprenticeship training program that currently limits employment to the private sector. And so that is a current limitation in our rules. That private sector limitation is not required by federal or state law. It's only a limitation in our agency rules, that Chapter 837 specifically. What we could do based on the current significant shortage in healthcare occupation, the commission could approve a short-term suspension of the private sector rule, that definition of apprentice, based on using the current rule suspension authority that's in TWC's agency rule section 800.8. If that were to be adopted, that short-term suspension that could address the issue of apprenticeship training program. The second program that we'll discuss here this morning is with regards to the skills development program. Have looked at enabling statute for the within the labor code for the skills development program, labor code section 303. General counsel office has found there's not an explicit prohibition to training for publicly funded employers in the labor code section for the skills program. However, the rule for skills development, Texas Administrative Code section 803 includes multiple references to training projects for private businesses. Sometimes they're referenced as private partner, sometimes business consortium. So while there's no specific mention of public employers, there is not, there would need to be applicable sections of the skills development rule would need to be suspended to allow for public entities to participate in the skills development. And there is a section of our current rule, 803.32 that would allow the executive director to suspend. It also allows waiver, but to suspend a portion of the skills development rules. So if the commission were to choose to go with determine that a pilot healthcare training initiative using skills program is appropriate, staff can identify sections that would need to be suspended in our current rule language, consistent with kind of what we talked about earlier on the apprenticeship in terms of the importance of the public healthcare industry or employers. The next steps that we would recommend is that we bring forward a comprehensive discussion paper that lays out the foundation for the commission and the executive director actions on both apprenticeship and skills programs. We can bring that discussion paper for the next commission meeting. And in fact, we have gone ahead just anticipating, because of the importance of this, included an agenda item for possible consideration on the May 31st commission meeting, which would consider temporary suspension of applicable rule sections due to an imperative public necessity. And at this point, that is the plan that we've brought back for your consideration this morning as far as the have been requested. So if you have questions, I'll be happy to address those.
Any questions for Mr. Townsend?
Good presentation, Randy. I was looking up what you were referencing when it comes to the skills development policy. I mean, the rules here, and I agree with you, the 803.32, the executive director or designee may suspend or waive section of this chapter, not statutorily imposed. So thank you for the clarification on that. I have no further questions.
I'm curious in regards to, there was a lot of the statute refers to private sector. And so in the analysis that comes back, or even some of our briefing, let's kind of talk about what was the intent behind that, where public sector entities were not included. I represent employers, both private and public. And so it would be a benefit on all sides, but I'm curious in regards to why public sectors weren't included from that standpoint. The second point would be, we'll discuss this particular issue, but the other programs probably are going to do the same. They'll want to look at your JET program, all these others that for a time being, we've not allowed public sector entities to participate in those programs. That's going to be something that if this is approved, you'll probably get the same thing down the line, same request down the line.
And I think the thought process to move this forward more quickly was for apprenticeship in particular, there is, as you previously heard in another commission agenda item this morning, there's applications are going out. I think part of that was just the timing to make sure that this would come in time.
Let's do this, gentlemen, if there's no objection. Let's let staff, we can't take action today. We don't have an agenda item for this. This is just informational. So let's let staff bring forward what they've proposed as they've proposed it. We'll have our typically comprehensive discussion here and take commission action next week.
31st.
What's today, 24th, next week. So Commissioner Demerson makes good points. Commissioner Alvarez certainly has an interest here, and obviously I do because I asked for this. So let's just do what you just recommended, and then we'll have a good robust discussion next week.
I agree.
In the meantime, you've heard Commissioner Demerson's questions. You can certainly be answering questions. I'm sure I'll have some as well. So all that can happen in the next week through our approved briefing processes. So,
yes,
all right,
that works.
I agree.
And have one other quick item. Just wanted to provide a status update. A couple of weeks ago in our strategic plan, we had received a couple of questions from the legislative budget board staff. We provided information. It was basically to add a couple of performance measures for one of our strategies that was for the state workforce services. Basically number of folks, participant to be served, and then average cost. So we've got that information back to the LBB staff, and it's been approved, and I believe we're ready to move forward. The budget structure is approved as well. So we're in good shape there. So
all right, very good.
June 1st. That was it.
Thank you. Thank you. Anything else? Any other item business come before the commission?
Chairman, yesterday we had an opportunity, all three of us got an opportunity to speak to the folks that were attending the workforce forum. So we appreciate those invitations to be there and catch up with good friends. We do have somebody here as a special guest from the Rio Grande Valley, Annabelle Cordona, who represents the Valley Grande Institute. We welcome her and glad that you were here today. So to join us.
Commissioner Alvarez, Annabelle is here as a guest, and she's an employer in our state. And so we appreciate that relationship as well.
And she has workers.
She
Just remember
does.
that. She got workers.
She's an employer that has employees.
100% of the jobs in this state are created by employers and 100% of those jobs are worked by workers. It's an irrefutable
right.
fact. So,
I just always, I know Commissioner Demerson always wants to get that plug in for employers. I gotta get that plug in for workers.
We don't take our employers for granted. So.
well, we've reached that point in the meeting. I do have a question. I see Ms. Arbor hiding behind so I had to leave early because I had another presentation I had to give. Did the man make it to the summit before I was cut short during his speech. I assume he made it to the top of Everest. Okay, good. That's good news. Thank you very much.
Where's
It's a good meeting going on. Our workforce boards from around the state are represented. Obviously others that are participating. Really good meeting, pretty aggressive agenda, I thought. So appreciate everybody, always trying to stay on top of the game. It's a complicated issue out
Yes,
there.
sir.
So anything else?
I also like to just inform everybody that Sunday you celebrated your birthday, and happy birthday to you,
Thank you
Chairman.
very much.
That's
Happy
it.
birthday.
Yeah. 22 has been, something like
Nice.
that. Any motion to adjourn?
Chairman, I move that we adjourn.
Second motion.
It's been moved second to adjourn. We're adjourned.